Who will be leading us off in this? Is that Carrie? Just 2 small items for you today, right, Carrie?
Yeah. Okay, I have is this working? I have a presentation. There it goes. All right, so Carrie Battistone with the Wildlife Branch of the Department. So I'm just going to go over today the 4 points we discussed for revision at the last meeting in June. So briefly, those are types of documentation falconers are required to carry, language regarding T&E species, language regarding suspension or revocation action, and language regarding unannounced visits. So the following slides will just go over those points. Also, as requested, we have provided a comparison table of state and federal regs for your information. So the first is the required documentation. So this language in the June version of the regs that you received was included in Section A2. A new section, Section A4, is added in what you have now to address what documentation might consist of. And you can read it here, but briefly, it may include, but may not be limited to, an original valid hunting license and required stamps when hunting with a raptor, permission to hunt on private property, permission to fly or hunt with another falconer's bird or birds, permission to fly raptor for rehabilitation purposes, or an exemption for flying a raptor that doesn't have a band. The second revision was regarding take of listed species. So this was in Section D of the regulations, and it had said that falconers should ensure that take does not occur. So the revision includes deleting that specific language where that was noted in the regulations before. So it now just reads as the first sentence in the original regulations only. The third point is regarding suspension and revocation. So the commissioners requested revisit this language, and it seemed that what you wanted was a list of specific violations that would not trigger a department suspension or revocation action. However, listing specific violations runs the risk of including something that the department might at some point want to consider. Or leaving something out that may not warrant immediate action. Rather than attempt to make an exhaustive list that may not capture all of these scenarios, our revision lists general criteria that would trigger immediate department suspension or revocation. These criteria are similar to restricted species statutes, which is in Fish and Game Code Section 2120. Okay, the last revision was regarding inspections. This is covered in Section J3A of the regulations, and there was some initial language agreed to in the June meeting, which we incorporated here, and that includes changing the word premises to facilities and adding a notification clause that the department will make a reasonable attempt to contact the licensee prior to conducting the inspection. And those are the 4 points that we've included in the revision before you.
Thank you, Kara. I think there was also maybe you mentioned. I think there was a discussion of what licenses, what paperwork they have to have in the field. Was that?
That was the first.
The first one. Can you just go back to that for 1 second? I'm sorry.
Sure. I think
So
we have to load it back up.
President Sklar, if I may.
I'm sorry, please.
Over here.
The speakers, I can't tell where people are talking from.
I believe that the language that was in the presentation for A4 and the department's most recent ISOR submittal have different language, and the included but not limited to language was eliminated and the list was made more specific.
Okay. One thing that I might, well, we'll get to it in a second, but thank you. I just want to say again, thank you, Carrie. Appreciate it. Really good work. I mean, you heard what we were talking about, and you made a real good effort to get it right. Thank you. Commissioners, any other questions or comments for Carrie, or before we go to the public comment? How many speakers do we have, Mary? And do we have any groups that are combining their time?
Yes, we have one group that's combining their time, and then we have 8 others.
Okay, let's have the group speaker first.
Peter Stroff. Do you want me to call all the other ones too, or just?
Let's have them speak, and then we'll do it.
Hello, my name is Peter Stavrianidakis. I'm a falconer in California and have began my falconry career at the age of about 20-ish in the early 80s, and a lifetime member of CHC. First, Glenn Stewart, president of CHC, asked me to make one request of you in his absence, and that was that we put off the notice of publication until we can have more time to meet and confer with the Department of Fish and Wildlife as to proposed languages that we're seeing today. That being said, I'll go into my presentation. In short, falconry, lead-free hunting for 5,000 years documented. We shouldn't be using more restrictions in this sport because it harms no one and takes a negligible amount with the 600, 700 falconers that we have in the state compared to every other way of taking fish or game in the state. I'm going to touch on these issues. One, I am here to exhaust all of the administrative remedies that are available to me in the current regulations that are in place and the proposed regulations that are hereby being presented. I'm doing this if there's a need for an action for declaratory relief. If there are any other administrative remedies that are available to me, it's now time to let me know, because I'm going to exhaust every one if needs be. Second, as we go down, I'm challenging the present actual litigation actual legislation that authorizes inspections without a warrant. I know the feds had something that they relied upon, they hung their hat on, but I as of yet to see the state legislation that gives the authority for a warrantless inspection. And I would like to see that, and I would ask that the Commission take note that they should be reviewing to see whether or not the proposed regulation is something that they can lawfully and constitutionally enforce and vote upon, because you have to have at least that as a threshold to discuss any issue regarding a new regulation. I'm also making a little challenge to see if the Department of Fish and Game can claim an exemption from the Civil Code of Procedure, specifically Title 13 at 1822.50 at SEC. That's the legislation that's been given for inspections. If you're going to have an inspection, these are the requirements. And to have an inspection with or without a warrant, it's required that, one, it be an issue of public safety. That's the either health and safety. For example, restaurants. They come and inspect the restaurants to see if the meat's being cooked enough, because that's a health and safety issue. They can see if your refrigerator's cold enough to make sure the meat you're eating isn't rotten. But here we have no health and safety, no public safety issue with falconry. What we do have is an intrusive regulation that allows fish and game wardens, law enforcement, guns and badges, to come as written to your home and as proposed to your facility. Well, the idea of facility, every falconer here, though they might not tell you because they don't want to open their doors up, brings their falcon in their house. We treat him in our house. We keep our food in the house. Some do, some don't. I live in a small little 400 square foot area. I live in a beautiful place with 40 acres, and I spend my time outside and don't need a big house. But it appears I would have to have an entire structure if I needed to protect my bird from inclement weather, heat, which is prevalent in the Central Valley, mosquitoes, which are everywhere, and I live on the river. So if I bring my bird in my house to protect my bird, I've opened up my house to warrantless searches. When I signed on with the falconry license, I didn't give a wavered consent of my Fourth Amendment rights. That's right against search and seizures. No falconer has done that. There's been no express waiver of any of our rights, but we're the only hunting agent individuals in the state that are open to inspections right now as written in their home, and afterwards as proposed to the facilities, which very well could include our home. Now, my wife didn't give up her rights to search and seizure, and she's not subjected to those. But her home's still subjected if she decides to stay married to me. So why interfere with my marital relationship so you can inspect my bird? Doesn't seem logical. And it's my position as an attorney for almost, gosh, I didn't have gray hair, and I had hair. And I'm 15 years at the Public Defender's Office doing nothing but defending the Constitution against these very types of intrusive searches and seizures. And I win on them when they come in without a warrant, unless there's exigent circumstances. And those almost never apply to the sanctity of one's home, and that includes the curtilage. So if your moose is in your backyard, that's part of your home. Now, if there's going to be an impingement on a constitutional right, such as the Fourth Amendment, the analysis is strict scrutiny. Because this is a very fundamental right that every American has, to be secure in their home and the curtilage therein. Strict scrutiny means you have to use the least restrictive means. And all I'm asking for, as that Fish and Wildlife, follow the law according to inspections and as propagated in Title 13, 1822.50 et sec. In fact, if they think there is an exemption to Fish and Game from following, or Fish and Wildlife from following this, they specifically name Fish and Game in it. And it's for searches, inspections, with warrants for fish, amphibia, and aquatic plants. Now, why would that matter? Because people eat them, they're commercially caught, they're stored in businesses that serve them, and so they want to be able to monitor how those items are getting there, whether they're fresh, whether they're safe, whether they're legally acquired. Not the case with the falconer. We're private citizens. I see my time is running short. So with that, inspections require under that code section that I cited 24 hours notice, person be present. They have to basically make an appointment. We're entitled to that. And the language is written says, we get to, if we make an effort to contact you, knock on your door and come on in. Well, the section requires a judge's signature with specificity that you can enter the premises without that person's presence. And thank you all for the time. I used my 7 and not a penny more.
Thank you.
I'll speak faster next time if I have left.
Thank you. Can you...
I'll answer questions if you have any.
Well, can you, the people who you're representing raise their hands?
How many falconers are here today?
But I'm asking who you specifically took the time from.
Oh, the time they gave the time.
There are 5. There
1, 2.
it's supposed to be 5 people. Right? Just kind of.
They may have left. Yeah, there's some of them left.
Okay. Okay. Fine. Any questions for? No.
I might have some questions in a minute, but yeah,
Okay.
just stay
I'll sit.
close.
If you have questions later, I'll be here.
Please read the name of the other speakers.
Marilyn Jasper, Eric Aroshal, Martin Bendor,
Come on up, somebody. While she's
Peter
reading.
Martin, Troy Morris, Bill Gaines, Carl Kirster, Doug Alton, and Terry Falconer.
First, I'd like to thank the Commission for doing the very important work that you guys do, and I'd like to thank the Department for being here and taking the time to create a very healthy dialogue on these issues. My name is Eric Ariyoshi. I've been involved in falconry since I was 12 years old. My mom helped me type a letter and send it off to the Napa Fish and Game office. I'd like to make 3 points today that I hope you'll take into serious consideration when looking at the revisions to the regulations. First, multiple studies have established that falconry is a zero-impact activity on the wild populations of raptors. Despite this fact, falconers are the most highly regulated group of sportsmen in America. Second, the falconry community has always worked proactively to, above all, protect the wild populations of raptors. The most obvious example of this is, of course, the recovery of the peregrine falcon. Private falconers donated their own breeding stock to drive these efforts, and without their cooperation with the other organizations, the recovery of the peregrine would never have occurred. So despite these 2 points, we as a community continue to be treated with suspicion, honestly, one level above assumed criminals. My biggest concern with the proposed falconry regulations has to do with the issue of inspections that have already been brought up. On this topic, the allowable inspections as currently worded constitute warrantless searches in conflict with the Fourth Amendment. Regulations require legal authority, and the reg must be consistent with both the law and not violate the Constitution. The adoption of the federal regulations by California cannot be grounds to violate the U.S. or California Constitution. And finally, there is no case law to support law enforcement centered the sanctity of one's home without a warrant. Applying for and accepting falconry licenses cannot negate the Fourth Amendment. To give this some personal context, being married to a county, is okay, a couple more seconds? Being married to a county deputy district attorney, I have some understanding of the challenge and the balancing act that law enforcement must use. I see her on warrant duty late at night, taking phone calls from law enforcement officers, and to be honest, I've seen the frustration on both sides firsthand. I realize the difficult challenge that all the sides have. But I implore the board that while this frustration can occur, these checks are in place for a reason. I really implore the Commission to not gloss over individual liberties in the interest of expediency. Doing so will only guarantee a lack of trust between the department and the falconry community, as well as likely legal action that, to me, is completely unnecessary. I think this can all be completely avoided if we correct the language today or in the near term and go forward as a partnership as opposed to one of conflict. Thank you.
Thank you for your thoughtful comments. Next, please. Come on up, somebody.
Good afternoon, Marilyn Jasper, Public Interest Coalition. We support staff's recommendation on this item to deny the revisions. Good points made about the warrantless search, but falconry, by its very nature, has to have a certain kind of a permit, and then the take of the activities can also be game. It would be like if I get home and the game warden or wildlife officer wants to check my deer tags. Does he have to go get a search warrant to do that? These are activities that have chosen to use their homes as the licensed facility, if you will, for the activity. I think there's got to be some leeway there for unannounced inspections. Thank you.
Hi, good afternoon. My name's Troy Morris. I'm going to be talking later on a regulatory appeal that I put in for American Falconry Conservancy, but right now I'm just speaking on my own. I'd like to point out that the searches that we were talking about here is a condition of a hunting permit. According to the department, Fish and Game Code 1006 allows them unlimited warrant access to all places in the state of California at all times. So according to the regulation as they have stated it, you don't have to be a hunter, you don't have to be a fisherman. They have the unfettered right to search any place in the state of California. That was what they said originally when it was addressed 3 years ago. It came up again. We had attorneys write letters questioning that authority. Recently, we had a meeting with the Fish and Game Department. They said, well, yeah, that's okay. So that doesn't give us authority, but we have to do it because it's in the federal regulations. The federal regulation gives the authority for the U.S. Fish and Wildlife to regulate these birds under the Migratory Bird Treaty Act, which specifically says that a warrant is required. There is no state authority to do these searches. There never has been. Right now, I'm sorry, I got off track. I'm going to come back to this later because Peter had mentioned the statute regarding inspections. I might add that inspections, according to the statute that he's reading, are voluntary. So if the fire marshal comes to your building, you can deny them access. if they want to, they can go to before a judge and get an inspection warrant if they have probable cause that a violation exists, and they have to make a notice 24 hours ahead. That's the regulation for businesses. This is our home. Thank you.
Please. Come on up, somebody. Please don't hesitate. Yes.
I'm Martin Benatar, and I'm on the board of directors for the California Hawking Club and have been so for 10 years. I've been involved in this process since they were handed off to the state in 2007. I spoke directly to Director Bonham in 2013 regarding the inability of the state to adopt the regulations in a timely manner. So he directed us to go upstairs that day at that Fish and Game meeting at the Resources Building to iron it out. Well, here we are, 3 years later, and we're still ironing it out. And in my opinion, that's just unacceptable. It's disrespectful to us. We're honest, law-abiding citizens. And when someone comes up and says, no, we reject that, no explanation, no rebuttal, no anything. Stafford graciously said, this is my commitment to you that we're going to attack this and we're going to get this right. The communication was great at the meeting, but when the meeting was over, the communication ended. So here we are talking about 5 items that we want to get the language correct on this so there's no interpretation needed. And to me, it looks like everybody is just glazed over with this process. And the process is not working. And so when something isn't working, it seems to me that we need to come up with a process that does work. Because diplomacy at this point on our behalf has not worked. I concur with Peter on the rest of the topics. Thank you.
Next speaker, please. Please, somebody come up right after the next person so that we're not waiting.
My name is Doug Alton. I'm lifetime member of CHC, member of AFC, American Falconry Conservancy. Very first falconer in the state of California to get a Golden Eagle permit. I'm a master falconer, bred hawks and falcons for several years. The concern that people have is, I've been inspected several times, and the wardens have been cordial, they've been polite, it's gone well, but it hasn't always for everyone. In 2003, there was some rumors tossed back and forth by some falconers, and federal agents were brought in from as far away as Ohio, in Region 6, Colorado, affected some nearby states, and upwards of 50 falconers were subsequently and simultaneously raided. One lady was terrorized, questioned, grilled for several hours, denied bathroom privileges, cried profusely, wet her pants in her own living room or kitchen. This went on and on. There was never any trials. There was a few minor pleas negotiated, but there was never any big convictions that they thought they were going to get. It was, the street name for this whole thing was Operation Witch Hunt. It was just a terrible thing, and over 50 birds were confiscated. None of them are alive today. All of them, we don't know what happened to them, but they're not alive now. But this is what's left a lot of falconers just scared to death of these kinds of permissions being granted to an otherwise cordial department to be able to do this sort of thing. Yeah, it's been good so far, but look at what the possibilities can be.
Okay, thank you.
Thank you.
Good afternoon. My name is Carl Kirster. I am a falconer, and I do abatement with my falcons, which are my pets. I use them to scare pests away from businesses and agriculture. My birds are my pets, and they're all captive bred. They're livestock. They're not wildlife. I use them to hunt wildlife and to chase pest wildlife away from businesses, but my birds are my personal property, and they should have no more status than a macaw, which would be a more dangerous bird that could actually take off a finger, which my birds couldn't do. My birds are my pets. The reason why you keep seeing falconry on your agenda is because it's overregulated. You've got too much going on in your regulations for it, and there's no reason why the department in California can't do the same thing that most states have done, which is to cut and paste the very most liberal method of regulation as allowed by federal regulations. There's a couple points in addition to the issue that everybody's so concerned about, which is the invasion of their home, and you can't believe all the horror stories that we can't even go through them all of wardens that have overstepped reality in people's homes. That can be eliminated by simply being reasonable and take a cut and paste like Texas, Nevada, Wyoming all did to have their state regulations. A particular item of concern is that the falconry regulations don't only affect 600 or 700 falconers. They affect 40 million Californians, because these are the regulations which allow or not allow the keeping of the livestock that I keep as my pets. My falcons are captive bred. They have nothing to do with the wild resource. And the regulations do not allow a private citizen to just get a peregrine. They don't even allow, the way that you've written them, to have somebody get an apprentice license and then buy a peregrine or a Harris hawk. They limit the apprentice to only certain wild birds, and that is completely ridiculous, and that would be changed if you guys would adopt the federal regulations in total, which, okay.
You
have a question?
Finish your sentence, but you got to wrap up.
I was going to say that at a previous meeting, you guys appeared not to realize what a lot of falconers speaking were referring to when they said adopt the federal regulations. What they meant was to adopt the most liberal form of the federal regulations. I wanted to clarify that.
Okay, thank you very much.
Good afternoon, Commissioner, staff. My name is Peter Martin. I'm a general falconer licensed in California. I'm here today as a friend of the Commission and the Department. I've been a sworn peace officer in California for over 35 years. I've only been a falconer for 3 years, so this is relatively new to me. I'm interested in it, so that's obviously why I'm here on the board. I wanted to talk to you about denying the notice today and adopting the federal regulations for California. Dr. George Allen is a biologist who worked for the federal government and did a 10-year study, if you will, of falconry regulations, met with participants from both sides all across the United States, and developed these regulations that we refer to as the federal regulations. The California Hawking Club's been involved with this group on the regulations since I think about 2005, and in 2013 I'm told that we were rushed into accepting regulations and told that we could come back and clean it up, which is some of what we're doing today. But as a board member, we haven't really been allowed a full say to explain our concerns and our interests in changes in the existing regulations. I don't understand why, with less than 700 falconers in the state of California, why we're so overregulated. I hear falconers on Facebook all the time talk about wanting to leave the state of California and go someplace less regulated where they can practice their falconry. I did want to talk real quickly about inspections. My concern with inspections is having wardens come to our homes or to our premises and inspect our facilities when we're not there. You can come inspect my facilities anytime you want. I don't have a problem with that. My concern is you going in and with my birds when I'm not there and trying to read the bans on them and possibly injuring my birds or a warden even. So that's my concern with that. In closing, I just wanted to say that falconry is a cultural heritage. My ancestors have practiced this heritage for hundreds, if not thousands of years, and I hope you allow us to continue it in the future. Thank you for your time.
Thank you.
President Sklar, members of the Commission, Director Bonham, and Department and Commission staff. My name is Bill Gaines, today speaking on behalf of the California Hawking Club. In Bakersfield, a couple of months ago, you did provide the department with some direction, I should say, on 5 topic areas to fix on the falconry regs. Kerry talked about that a little bit earlier. You also asked the department to work in good faith with us in the meantime to bring back a package to this meeting that hopefully had some consensus associated with it. That really did not happen. I want to talk specifically about 3 areas. First one is documentation. Certainly reasonable to expect a falconer to have a hunting license and his falconry license in the field with him while he's hunting, but the long list of other documentation that falconers are, per the department's proposal, required to have with them simply is not reasonable. Putting in the regulatory language that it needs to be somewhat accessible, not necessarily on their person, but accessible, is something that we think is reasonable. That information is available online, which would even be more reasonable to have them pull it up online. But if they're off the grid, at least having it in their rig or somewhere close, but not necessarily on their person, we believe is reasonable. Revocation, simply want parity with other methods of take, where 3 violations in 5 years, yeah, you can get your license yanked. With falconry, they want to be able to yank it for 1 simple violation. I don't call that parity. I don't think that's reasonable at all. Lastly, on inspections, again, as we've talked about before, we believe the federal language should have just been adopted on this. The federal language should have been adopted for the entire regulatory package. That's still the position that we would like to see take place. But a couple of issues specifically in regards to inspections and the language that the department is bringing forward for you to publish notice on today. As far as wardens, you heard Pete Martin talking about this. Wardens entering the cage to check a bird's band without the licensee there will create serious problems for the birds and could create serious problems as well for the warden. We do think that that language should be changed so that the permittee needs to be present if they are going to enter those cages, and that's for both the safety of the bird and for the warden. Lastly, the language that the department's bringing forward to you today says a reasonable attempt will be made to contact the permittee before they inspect the facilities. What does reasonable attempt mean? It needs some specificity, 24 hours or whatever it may be, but simply saying reasonable attempt, I can assure if you ask a warden, they're going to think one thing. If you ask the licensee, they're going to think another thing. That needs to be more specific as to exactly what a reasonable attempt is. And in closing, the right thing to do simply would be to deny notice today and direct the department to go back and start working with the federal regs as their baseline. We're under no timeline here. We haven't been through WRC. We haven't been through the typical process for a lot of these things. Denying notice today and allowing us to go through that process and truly begin some good faith negotiations on language would be the right thing to do. We urge you to deny notice. Thank you.
Thank you, Bill.
Oh, well, good afternoon, Commission, Department, and staff, and thank you. My name is Terry Faulkner, and I have been a wildlife rehabilitator. That, in many ways, that's how I started. That and other school things that we don't want to go into. When you visit somebody's home, it is a matter of respect to give them some sort of notice. And I believe that a reasonable accommodation and notice should be made and should be answered and appointments should be made. As in, if somebody comes to my home, I don't want them shooting my dog because my dog objects to them being there because they're afraid of my dog. Or my donkey, which is worse. This is simply a matter of respect. And People who hunt with birds should be entitled to no less respect than those that hunt by any other means, be it guns, bows and arrows, or whatever. As I mentioned, I have worked on wildlife rehab, and many of you, well, shoot, you know with your own animals. When a stranger comes in, they're under more stress than when their owner's there. So please respect that and allow their owners to be present to everything. Thank you.
Thank you. Are there any other speakers? Okay, commissioners, any questions? I have a couple after you guys, but please, Commissioner Williams.
Thank you, Mr. President. A question for the department. Just on this issue of the search and seizure, could you remind us if the department has the authority for any non-present searches or inspections where the subject or the licensee is not present?
Yeah, Commissioner Williams, I may ask one of our deputy general counsels to just go up to the, might be easier there. But I'd also say that a couple of things first. There was a citation given to Section 106 of the Fish and Game Code. I think that's incorrect. I think the speaker meant to cite Section 1006,
yeah,
which is about inspections.
Correct.
Second, here's what I don't understand. Set aside the very eloquent first speaker and the Fourth Amendment issues, which I think are worth pausing and discussing, but set that aside for a minute. As best I can tell, since Bakersfield, the department did exactly what the commission asked. We changed premises to facilities. We specifically identified certain things that would need to be had in the field, notwithstanding Mr. Gaines' comment on that, which I think is legitimate. We purposefully shifted a burden. No longer will the falconer have to prove they won't cause an impact to T&E species, threatened and endangered. Rather, we're just confirming this is not an authorization for such an impact. And we narrowed the scope of revocation. I didn't hear any of the speakers say whether those changes are better or worse, acceptable or not. And that's where I think the department is stuck. We've had a lot of conversation with the falconing community. We're willing to keep sitting down with them. If you were going to propose delay of notice intent, or if you were going to go to notice to intent, we'd still keep sitting down. But it's not obvious to me as an observer. There's a willingness on either side to try to get to yes with finality. I didn't hear anyone acknowledge those concessions that have been made to improve the language to lessen the burden on falconers, setting aside the Fourth Amendment issue, which I think is a legitimate one I want to think through a little bit more.
Right. So let's come to the Fourth Amendment issue in a second, but I'd like to comment, Director Bonham, on what you said, and it's my observation as well. I think the department's made a really good effort and a successful effort for the most part to answer the concerns that were raised and the commission's suggestion for how to solve them. Whether or not you've gotten a confirmation of that from the falconers, that is my observation objectively, that those are the concerns we raised and they've been answered, maybe not to their satisfaction, but I think very close to what the commission asked as a solution to the problems, because as the first speaker, who is very eloquent and is a very talented lawyer, said, a lot of this is a balancing act, and that's our job, is to figure out the right balance. So I do want to compliment the department on that and say the fact that you haven't gotten a positive response is in some ways not fair, number one, but also from my perspective, you've done what you've been asked to do.
So I think one of our talented lawyers can answer directly your question, whether there are other components we think in statute that provide the department that kind of inspection authority.
Before you answer, let me just say I agree with you, President Sklar, that I think the department has done an outstanding job of responding to the issues that we raised. I think, and even if we have questions or discussion about this, I'm not sure that they can't be answered as this continues along in the process from my perspective.
And let me make an offer on that point. And I say this not as if I had extra time available, but if you were to go with a notice of intent to amend, we still would have discussion and decision over
Correct.
6 months. Or if you elected to delay notice of intent to amend, under either pathway, the department will sit down with an appropriate delegation from the falconer community, and I'll try to schedule it such that I can be available and watch the rhythm and pace of the exchange to see if it's possible. Because if you were to notice intent to amend, we still have more room for language discussion,
Right.
assuming we're in the scope of what you're noticing. Or if you elect not to, we would sit down for the purposes of seeing if we can further refine the dispute and find some surgical language that can work for both sides.
Yeah. Thank you. All right.
Counselor.
Please proceed.
Good afternoon. My name is Ann Malcolm, and I'm an Assistant Chief Counsel with the Department of Fish and Wildlife. And if I remember the question correctly, it was, does the department have the authority to conduct inspections when a member of the regulated community is not present? And the answer to that is yes. So the authority to conduct inspections without a warrant really derives not just from statute, but from a body of case law that deals with what are called highly regulated industries. And even Eric maybe inadvertently used that term, but falconry, along with hunting, fishing, daycare centers, nursing homes, are all heavily regulated industries that the courts have acknowledged give law enforcement special authority to enter into premises. Now, they don't enter for the purposes of general law enforcement, which is the folks that are used to dealing in the normal criminal world. Law enforcement officers are going into places for general law enforcement purposes. These special privileges that come in highly regulated industries are for the purposes of conducting inspections. And falconry is not being singled out. There are several other provisions in your regulations that give our peace officers, our wardens, the authority to conduct inspections under almost identical circumstances. Native reptile propagation, PLM, the PLM licenses, scientific collecting, fallow deer farming. In all of those areas that are highly regulated, that are in Title 14, the Commission has given our peace officers the ability to go in and inspect facilities. I would also, there has been a lot of discussion about the federal regulations, and I wanted to just quote the section of the federal regulations so everyone's aware of what it requires and what it doesn't. So under the federal regulations, it says, you must submit to your state, tribal, or territorial agency that regulates falconry a signed and dated statement showing that you agree that falconry facilities and raptors may be inspected without advance notice by the regulatory authority at any reasonable time of the day, but you must be present. So I think it's important to note that in addition to acknowledging that there is a special role for agencies like the state of California that are regulating this, the federal government also empowers California to go farther to the extent that we believe it's necessary to protect our resources. It says our laws can be more restrictive than these federal standards, but may not be less restrictive. We've determined that for the purposes of the protecting the birds, protecting public safety, protecting livestock, that our peace officers need the ability to enter into these facilities. And again, the location in which the falcons are kept is entirely within the control of the falconer. So to the extent that they're allowing an intrusion, a search, they have control about where they keep those birds for the purposes of our inspection of those facilities. So I'll leave it at that. I'm happy to answer questions or address any other issues you'd like me to.
Okay, so, and again, this is not necessarily to settle this issue, but it is, again, complimentary of the department for making the changes. I just want to make sure that as to this provision, I have some comfort that it's in a condition to at least start the process. And so this issue of presence versus not presence is one that I'm still a little bit hung up on. You cited the federal provision that does require that the licensee be present, correct?
Yes.
You also mentioned other circumstances, and I just want to be clear, in those other circumstances that you mentioned, does the regulated person or the licensee, are they required to be present during those inspections of daycare facilities and those types of things?
I'm not familiar with the specific regulations having to do with daycare facilities, but I do believe for all of the provisions that are in Title 14 that are commission regulations that they do not require that they be present. And I'll confirm that. I'm assuming the discussion will go on. I'll confirm that with the regulations. But was that?
Yes. Commissioner, I'll just say, again, under either pathway, you approve notice of intent to amend or you don't. I'm committing to additional conversation. And on this narrow point, I would want to make sure the state language we're suggesting includes the presence of the permittee, which is in the underlying federal language as I understand it.
I mean, another alternative that we could discuss is any other responsible adult. I mean, there's ways to kind of get potentially in the middle that I wondered if was it Pete who I think I talked to? Yeah, sorry, the one behind you, the Peter and Pete. I'm sorry. Thank you, Counsel. So we had I should state for the record that we had a conversation. I spoke with you one-on-one on this topic, and I also spoke with other members of the falconry community yesterday by telephone about this issue. So I wanted to ask you, Peter, because this was not, I was not aware of this at the time that we spoke, but there is a state Supreme Court decision. I'm not sure if you're familiar with People versus Machio. I think that's how you, Mikio? Mikio. Are you familiar with that?
I'm not, but it doesn't mean I haven't heard the language about it, but the name isn't ringing a bell to
Okay,
associate
so
with the...
at the risk of turning this into an oral argument, let me just ask you, I'll give you the site. It's 51 Cal 4th 1074. I think it would be to your benefit to take a look at that case because as we progress, again, I would be curious to know what your response to it. In general, the Supreme Court essentially says that there is that it is not violative of the Fourth Amendment for the department in the enforcement of and carrying on its duties to engage in warrantless searches in certain circumstances. In this case, it was a situation where the officer believed that there was some potential poaching, didn't have reasonable suspicion that that was the case, but under the authority to basically enforce the law, was able to do a warrantless search of the person, their vehicle, etc. Again, not their homes. There are some distinguishing factors here, but I think the rationale that they gave is reasonably applicable to this situation. So I would encourage you to take a look at that case.
I will. Did you have a question for me, or
I
just want to give me advice?
I wanted to know if you were familiar with it. If you were, then I might have asked you a question about it, but I don't want to get into a whole discussion about it.
Were there any other questions of any other individual?
I don't believe so.
May I make a brief response to the issue of highly regulated industry?
Well, we're going to discuss that, but this is not going to be the last opportunity to talk about this. Yeah. Let me make a few comments. All four of us commissioners, I believe the director as well, are under our current position sworn to uphold the Constitution, both of California and the United States. Both Anthony and Chuck are officers of the court, which give them added requirement to that. And I think beyond our responsibility that I am certain that all of us deeply believe in our obligation to defend the Constitution. There are exceptions to most of the amendments to the Bill of Rights, limited, and they should always be limited, and they should be given incredible scrutiny. And I know from the tone of what Chuck is saying that that's what he's saying and feels too. I don't think any of us disagree with that concept. There are exceptions, and I have deep familiarity with regulated industries. All three of the industries I've been involved in my whole career: restaurants, agriculture, and winemaking. Alcohol is actually one of the most regulated industries in the country, probably only slightly less than nuclear power plants. Depending on what the violation may be, the exceptions are greater or lesser, because it's these things have to deal with the real world. Somebody said once, the Constitution is not a suicide pact, and that's why there are exceptions to the most extreme, to even the most important of our amendments, including the First Amendment, right? And I didn't think when I swore the oath to the Constitution that we'd be having a lot of constitutional discussions at the Fish and Game Commission, but it's important and we take it seriously. It's my suggestion that we move forward with the notice to publish the notice, and I have one suggested minor change to the wording today, and then I think we take Director Bonham and the department's offer up to continue to fine-tune the inspection language. I don't think we should try to fix it today, because I think there's some work that needs to be done and understanding that needs to be gained to do that. We will have at least 2 more meetings in which to fix that language to get it precise. The one thing I suggest we change is on the documentation required in the field, that we change it to in the falconer's possession and accessible, meaning it can be in your truck. It does. I understand that you can take 10-mile hikes to go hunt and to find or to find a bird, and to carry a huge amount of documentation is unreasonable. But because where you're doing this, electronic access may not be possible, that's really not a solution. So I suggest that simple change in language to in possession and accessible in the documentation in the field, and then I suggest that we move to the motion to publish. Any commissioners have a different thought on that?
Again, I appreciate Director Bonham's commitment and the department to work with the falconers and to really work on language and to come to an equitable solution. And I take him at his word, and I think you should too, because that's the goal, is to work it out.
I believe there was just one more issue that they brought up, was the revocation issue, which, probably values some further discussion, I think so.
Yeah, good. I think that in large measure, by narrowing it to a very few issues that result in immediate revocation, I think we're getting real close. Any other violations have a much more staggered and step approach, but absolutely we can discuss that further. I want to once again thank the department, because just because people who are zealous about what they do, which is a good thing, I'm passionate about wine. I appreciate your passion about your falconry. I don't think just because the speakers today have said that the department hasn't worked hard at this and tried to do a job in earnest, that's true. My observation is that you haven't, so I want to thank you again, Carrie, particularly for your hard work on this for many years now. I think you've gotten to a really good product. I would also suggest to the falconer community that we get over and move on from the adopting the federal regulations. That's this commission, previous commissions, well, with only Jackie maybe the only one who's remaining from that, have made it clear that we're creating our own regulations here. And as the counselor said, that is what the federal regulation said we can and should do if we choose. So I think we need to move beyond that and work on getting this regulation as good as we can. With that, I'd entertain a motion.
I'll make a motion that the commission authorizes publication of a notice of its intent to amend Section 670 regarding falconry regulations.
I'll second that.
If I could, that's as identified in the ISOR with Professor.
Thank you.
Yes.
President
This is taking it back to
Sklar's,
law school, this whole discussion.
with President Sklar's additional
Amendments.
clause added.
Mm-hmm. Yes.
Okay.
That's my second as well. Roll call, please. We can just do it by voice. All in favor?
Aye.
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 Any opposed?
Sure. My name's Troy Morris, speaking on Fish and Game Code 670J, J1A, and J1B.
Well, what topic? Because we're not.
I'm sorry. The falconry inspections.
The falconry. Okay, please go ahead.
Okay. Essentially, to start off with, as based on my request, the authority that the regulation that's been put on the books is illegal on its face. According to APA 11349B and 11349E, the authority, which is the statutory law that allows the authority, needs to be printed in the California Code of Regulations, as well as the reference. Earlier today, you heard from the department's attorney, and you asked her for the authority for these searches. She didn't give you the authority. She quoted some vague references of law about highly regulated industries and special rules. First of all, falconry is not an industry, it's a sport. And we are not asking for standards, you're asking for the law. She didn't cite the statute, and since it's required according to the APA standards as a matter of law, since it hasn't been filed, the law is illegal on its face. We've been asking for 3 years from this commission for the authority for the searches to search our homes. I have heard the commissioners in the past, none of the people here, state that they have the authority to search these places at all places and all times. I had a 20-year law enforcement officer plead for you to pay attention to his Fourth Amendment rights. They laughed at him and they said they had the authority. It's not been published in the federal in the CCNRs, and it's still not published today. When we ask people what the authority is, they tell us it's 1006, which is kind of ironic because 1006 is been proven to not mean that. If you listen to the People versus McKeel, the findings of the Supreme Court Justice, it's pretty clear that that doesn't give the authority to search people anywhere they want. We have basically two questions. What are these administrative inspections, or are they law enforcement searches? And if they're either one, who authorized these searches or inspections? Not even Congress has the authority to grant this permission. It's not published in the CCRs, and therefore it's illegal on its face. Again, Fish and Game says that the search authority is provided in 106, and the Supreme Court in People v. Keogh is in opposite of that. We understand that hunting and fishing is highly regulated. However, part of the problem comes from the Game Department's definition of falconry. The mere possession of a bird in your backyard is not falconry, any more than having a fishing rod and reel in your closet is fishing. Residential and administrative searches must be in the interest of health and public safety, and they're compulsory only when accompanied by an inspection warrant, as Peter had said earlier, based on probable cause according to CP 1822.50. Based on the authority granted to the Game Department by this board, other people on this board, agents for the Fish and Game are conducting inspections now that have routinely been used as a pretext as evidence for criminal violations. I can give you phone numbers. Such reckless disregard taken by people, such reckless disregard for our Bill of Rights has resulted in officers who have taken an oath to uphold the law to violate one of our most precious rights, the right of the people to be secure in their persons, houses, papers, and effects. This regulation remains. If it remains, this commission is publicly declaring that Fish and Game Code 106 authorizes law enforcement to enter the homes and properties of all hunters and fishermen to inspect their gear and paperwork as well. I'll make it clear, 106 is a blanket search authority that was written in the 30s to authorize the Fish and Game Department, and it was a directive at that time that you shall regularly inspect all boats, markets, containers where these fish and crustaceans are found. The Supreme Court made it pretty clear that wasn't directed to be used to search the vehicle of a hunter in the field, even when he was hunting and fishing where wild game exists. It certainly doesn't apply to our homes. So
Thank you.
if this board really cares about the Fourth Amendment, you'll show us the legal authority or you'll repeal it.
Thank you. I would state that we haven't passed anything yet. We're in the process of discussing this and how to make this better. So that's exactly what we're doing, is trying to correct this in any way we can to make it perfect. This isn't a debate. I'm just explaining, as we discussed before, as you heard, you're here, we're going to work this process through and we're going to make sure that we make the right choice on it. So thank you for your additional comment today.
Thank you very much.
Next speaker, please.
So I believe we have some speakers. You're taking all of item 38, correct?
Yes.
So if you wanted to speak on 38 and I called your name, please come forward.
You can call those names again if you want real quickly, just so we make sure that everybody...
George Osborne, Carl Kirster, Shirley Louse, and Marilyn Jasper.
Okay, please come on up.
Good afternoon. Shirley Loust, the Governmental Affairs Coordinator for Trinidad Rancheria. And I would like to address the complaint submitted against Commissioner Hosser Carmison under item C, I believe. I've had multiple opportunities to observe Commissioner Hosser Carmison in various settings, such as the Tribal Committee, work groups, and public hearings. One such hearing was at the Yurok Tribe regarding the Blue Creek Refugia. Commissioner Hosser Carmison always conducts herself in a professional manner, going above and beyond merely facilitating meetings. She consistently and unfailingly accommodates all participants, providing an open and fair forum, drawing out and intently listening to all stakeholders. She takes great care not to involve or represent Trinidad Rancheria in commission matters, and she is extremely conscious of her role as commissioner and mitigates the possibility of perceived bias by conducting herself in an open and transparent manner. So it's my opinion that there is no valid or factual basis for the complaint against her. Thank you.
Thank you, Shirley. Appreciate your being here and appreciate your words.
Thank you.
Anyone else? Okay.
I'm sorry, I forgot to submit this.
You feel free to give it to them. Thank you. I have one suggestion on the ferret petition, and that is that we do one of two things. Either we ask the staff to review the checklist and then provide information to the folks who submitted it about what their next steps are, or we can continue it to the next meeting and get a report back from staff on the checklist. Which do you recommend, Val?
Either are fine. We could also, work with the department to review the checklist document and make sure that it's adequate, and then decide on it at the next meeting.
Okay, so why don't we continue it? That way you guys can report back to us on it, and then. Is that good for everybody? Okay, so that would mean that we take the second motion. So I'll move it. That the commission adopts the staff recommendation for. Oh, sorry, Erin.
I just wanted to bring it to your attention that we did not cover item 38C.
38C, okay.
Which is the items pending petitions and non-regulatory requests. So in February of 2016, the Commission referred a regulatory petition number 2015-004 requesting a change related to native reptiles to the department for evaluation recommendation. The department has completed their review and is recommending scheduling that for rulemaking in 2017.
Okay, terrific.
So that is part of your motion as well.
Okay, so we're passing. Then the only two changes we'll be making then are, just so I'm clear, is that we're accepting all the recommendations except that we're not acting on 2016-11 because it was removed, and on 2016-08 we'd be asking staff to continue it to next meeting. Okay, so I'll make that motion, that the Commission adopts the staff recommendations for actions on June 2016 regulatory and non-regulatory requests, including item C, except for item 2016-8, which we continue to the next meeting, and 2016-11, which was withdrawn, and that we approve adding petition. I'm sorry, I'm repeating myself there, but we approve adding petition 2015-04 to the 2017 regulatory calendar. That's my motion. Is that clear, Mary? Are you clear on what I did? Good. Yeah, good. You're good. Okay. So I made the motion. It's seconded by Commissioner Williams. All in favor? Aye. Any opposed? Three in favor and 2 absent. And before we wrap up, just a couple things. Val, do you want to have a couple announcements? Then I have a couple things before we finish up.
Sure. Just a few announcements. Reminder for the December 2016 our meeting. The name of the hotel has changed, not the location. So if you plan on attending in December, the name has changed from the Portofino Inn and Suites to the Hilton Garden Inn in San Diego. And just again, another note for 2017. We're switching the marine and non-marine days. So the first day will now be wildlife and inland fisheries topics, and the second day will be focused on marine items. And then lastly, another plug that our Deputy Executive Director position is posted, and every smart person around should apply. Thank you.
Thanks, Valerie. We're going to do 2 more things before we finish up. First of all, I don't do this every time. I should, and I want to. I want to thank all the Chief Best and all the wardens who are here with him today for the work they do for our state, for this department, on behalf of the Commission as well, and for providing for our safety here. We really appreciate the work you do, and we don't say it enough, but I want to say it today. So thank you all. Lastly, I'd like... Lastly, I'd like to turn the floor over to Commissioner Williams to adjourn the meeting with some special comments.
Thank you, Mr. President. It's with a heavy heart that I announce that Greg Schmidt, who was the longtime Secretary of the Senate here in California, passed away in his home yesterday. Greg is one of those people who toil behind the scenes. As Sankey always said, when you go up to a storefront, you see most of what the public sees is the front, and they don't see what's behind that. We kind of get a taste of it with our staff here, with the Commission, and with the Department. But there are thousands of others who serve the state extraordinarily, and Greg Schmidt was one of those people. If it's all right, I'd just like to read a statement from former President Pro Tem Darrell Steinberg. Greg was a good friend of mine and a mentor to me, so I just want to give this honor and recognition to him. Greg lived an extraordinary life of public service that witnessed, shepherded, and safeguarded 18 years of California legislative history at the helm of the California State Senate. He was a custodian of both the Senate's rich traditions and history, on whom its staff, members, and reporters would lean heavily for counsel. He was a mentor, unselfishly committed to ministering a Senate staff of thousands during his remarkable tenure, and he was a guardian of the Senate's honor who served with compassion, discretion, and an unwavering resolve to champion the constitutional principles of the legislature and democratic governance. With that, I would just ask that as we adjourn our proceedings today, we do so in memory of Greg Schmidt.
So ordered. Thank you. We're adjourned.